La di da di da. La di da di da di da. La di da. La di da. La di da di da. I really need to do an introduction, don't I? But hey ho. Let's see if anyone joins me. It looks like I've got one concurrent viewer. We've got some breaking stuff. It's quite late here, but I'm going to try and get through some of it. Although I've got lots on the Springer stuff. Well, let's start with his appeal, and then people can catch up. Hello, Internet God, Griffey, Matthew, Cliff Higson, Rebecca's Dirty South Cats, and Alex. Right, we'll do Springer's Notice of Appeal. Then we'll do Joseph Amico's Probation Terms. Just turn myself up a bit because I'm a bit low. And then we'll do some more Springer. I mean, there's quite a lot of Springer, so I don't know if we'll get through it all, and some of you may get quite bored with it. But anyhow, first one is Notice of Appeal. James Springer v. 7th Judicial District Court. Mercedes Murphy, Shannon Murdoch-Poff, Jason Jones, and Susan Rossignol. Notice is hereby given pursuant to Federal Rule of Appellant Procedure Rule and from 28 USCA 1292 that plaintiff James Springer hereby appeals to the United States Court of Appeals for the 10th Circuit from the amended memorandum opinion and order of this court, denying plaintiff's request for temporary restraining order and preliminary injunction, submitted this 29th day of September. I don't think I have ads at the beginning of my live streams. I shouldn't have. It should be ad-free, my live streams. So that's the appeal. So he has appealed to the 10th District. There is more on Springer, including a request for a judge to recuse herself, but we'll have a quick look at Vegas Valley and then come back to Springer. Right, we got the judgment on Vegas Valley. And as you all know, he pled guilty and did a plea deal and got sentenced to 30 months, of which he thinks he's going to serve about 13. Those were the charges. He pleaded guilty to one count of cyber stalking and stalking cause substantial emotional distress. And the date of the offence was August 22. We all knew about that. The defendant shall serve his sentence at a suitable Bureau of Prisons facility as close to Las Vegas, Nevada as possible. I know he was hoping to go into California. I don't know if that's going to be the closest one. The defendant shall be allowed to participate in any mental health and substance abuse treatment programs for which he is determined to be eligible while spelled incorrectly, in Bureau of Prisons custody. And there is no date for him to turn himself in to the US Marshals. And this is his supervised release. And he's got a term of 3 years. Obviously not commit any crime, possess a controlled substance, 1 drug test within 15 days of release from imprisonment, and at least 2 periodic drug tests thereafter as determined by the court. Must cooperate in the collection of DNA as directed by the probation officer. And there's the standard terms. I'll just flick through them. It's not worth reading them out, I don't think. Nice work full-time one there, at least 30 hours per week. But if you want to read the standard ones, you can obviously pause and read them at your leisure. But let's have a look at the special conditions of supervision. The defendant shall participate in a program for substance abuse, including substance abuse testing such as urinalysis and other testing, and shall undergo a drug alcohol evaluation and treatment if substance abuse is indicated by the testing. The probation officer will supervise the details of any testing and treatment, including the selection of a treatment provider and schedule. If inpatient treatment is recommended, however, it must be approved by the court unless the defendant consents. Did that make sense? The defendant is not to leave treatment until completion or as ordered by the court. While in treatment and after discharge from treatment, the defendant is to abstain from the use of alcohol. The defendant is required to contribute to the cost of services rendered. The defendant is to participate in a mental health treatment program, including a mental health evaluation and any treatment recommended. The probation officer will supervise the details of any testing and treatment, including the selection of a provider and schedule. If inpatient treatment is recommended, however, it must be approved by the court unless the defendant consents. The defendant is not to leave such treatment until completion or as ordered by the court. While in treatment or taking psychotropic medication, the defendant shall abstain from the use of alcohol. The defendant is required to contribute to the cost of services rendered. The defendant shall not have any contact directly or indirectly, including through social media, telephone, text, mail, or email, with the victim AD and the other individuals who are identified through this investigation as victims of similar conduct, including PC, KE, MT, and PH. The defendant shall not knowingly contact directly or indirectly the aforementioned individuals' family members or their current or prior places of employment. Sounds like he had quite a session of harassment. The defendant shall comply with all orders of protection. The defendant shall notify the probation officer of all orders of protection. The defendant shall submit to a search of his person, property, vehicle, place of residence, or any other property under his control based upon reasonable suspicion, and permit confiscation of any evidence or contraband discovered. And his monetary penalties were $100. I thought I was reading a name there, but it's the name of an act. Payment to begin immediately. The defendant shall pay a special assessment of, I can't highlight it, of $100, which shall be due immediately. So that's it. Not a lot of money he's got to pay. Nothing so far on these special conditions of his, with taking into account other offences. We've obviously got, it obviously includes the offences against these individuals here who were mentioned, but nothing else. Right, back to Springer. So I did document 39, which is his appeal. We'll now go on to document 40, which is an expedited motion for the Honourable Margaret Strickland, U.S. District Judge, to recuse herself from all proceedings going forward and reassign the case to consider this motion, pursuant to 28 U.S.C. Section 144. Comes our plaintiff. hereby respectfully moves this honourable court, by and through his undersigned counsel of record, for an order from this court. 1. Recusing the Hon. Margaret Strickland from all proceedings going forward in this case, pursuant to 28 U.S.C. section 455 brackets A. Surprised Chile hasn't tried this one yet. Reassigning this matter to another U.S. District Judge for the District of New Mexico, pursuant to 28 U.S.C. 144, and for such other and further relief as this court shall deem proper. We know the background, but the first sentence, this motion is not undertaken lightly or without great care. One or two instances of deference or understanding for procedural process violations for unsophisticated litigants is entirely understandable, but several acts of leniency for the most sophisticated litigants invokes a duty of counsel to request that another district court judge conduct an evaluation of whether the leniency shown to counterpart state judicial defendants by Judge Strickland may reasonably question her impartiality. Ooh, impartiality of a judge. Multiple instances of service of the orders requiring a response and of the complaint and summonses is well documented in the records, and they're numbered. However, instead of responding to the request for injunctive relief within 14 days of either June 21st or July 13th, defendants, despite acknowledging this matter on the show cause proceeding record, selected to intentionally ignore the requirement to do so under Judge Riggs' order. Because inexplicably no response was filed within the 14 days as required by the court, plaintiff, following the magistrate's order set in a status conference, endeavoured to achieve the injunctive relief he was entitled to have received upon the defendant's default by filing a notice of briefing which contained his declaration verifying the factual allegations of the complaint, which included a motion for a temporary restraining order and preliminary injunction. Following the submission of document number 25 with its attachments to Judge Strickland's proposed text email address on August 10, 2023, and there is a exhibit of that, plaintiff received an email on August 16, 2023 from Chambers acknowledging receipt and providing that the court was reviewing the submission, including the attachments which included plaintiff's declaration. On August 15, 2023, a day prior to the court's email that it was reviewing the submitted packet on the defaulted motion, counsel for defendants entered their appearances. Almost a week later, with no request made to the court that plaintiff was party to, the court, sua sponte, excused the default of the judicial defendants of well over 2 weeks and provided them with an additional 15 days to file a response. Must be a crooked judge. Following the submission of the response from defendants and the reply from plaintiff, the court, without any affidavit or declaration from defendants, proceed to determine facts in favour of the defendants, to ignore the submitted declaration that court had acknowledged receiving and to reviewing, and to ignore the deficiencies in the briefing of defendants which argue conclusory statements regarding the requirements for injunctive relief, including ignoring the tacit omission that at the very minimum plaintiff's claims for violations of his procedural due process rights, because he was awarded absolutely no pre or post deprivation due process, were valid and undisputed. Thus, plaintiff made an uncontroverted showing that he was substantially likely to succeed on the procedural due claims, to say nothing of the other claims when viewed in light of the facts contained in the verified complaint. Yet, despite uncontroverted showings of rights being violated and irreparable harm to plaintiff, Judge Strickland took the statements of justification for the deprivations as true regarding plaintiff's harassment, without verification, to deny the injunctive relief requested twice. First, by relying on a lack of factual verification, which the court stated it had reviewed, and then following a second time without any consideration for the impact that it should have made for plaintiff to have verified facts and defendants to have controverted none. In further deference to the judicial defendants, Judge Strickland also required that the plaintiff show cause why, despite great effort evidenced on the record, his complaint should not be dismissed for lack of prosecution because the defendants remain in default, refusing to file an answer to the complaint, or that plaintiff must file a disfavoured motion for default, this in spite of the fact that it is clear that defendants are the party that should be required to show cause why they have not provided an answer to the complaint and why they should suffer default judgment. It is not reasonable to place a burden on the plaintiff to show why his case should not be dismissed after he has undertaken and proven that he is suffering an irreparable injury at the hands of the defendants who have appeared before the court and have inexplicably refused to follow court orders or the rules of procedure requiring a responsive pleading. Argument. Recusal of the court and reassignment is merited under the circumstances. Reassignment of this case to another Article 3 judge is merited under Section 144. Sorry, it's getting late here. 144 provides as follows. Whenever a party to any proceeding in a district court makes and files a timely and sufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice against him before whom the matter is pending has a personal bias or prejudice either against him or in favour of any adverse party, such judge shall proceed no further therein, but another judge shall be assigned to hear such proceeding. The affidavit shall state the facts and the reasons for the belief that bias or prejudice exists, and shall be filed not less than 10 days before the beginning of the term at which the proceeding is to be heard, or good cause shall be shown for failure to file it within such time. A party may file only one such affidavit in any case. It shall be accompanied by a certificate of counsel of record stating that it is made in good faith. Attached hereto is the declaration of James Springer. I'm going to look forward to reading this, I think. Made pursuant to 28 U.S.C. 1746, filed in support of this demand for reassignment. And there's a citation. So long as the documents comply with 28 U.S.C. section 1746, a district court should not unnecessarily hypertechnical and overly harsh should not be unnecessarily hypertechnical and overly harsh on a party who unintentionally fails to make certain that all technical, non-substantive requirements of execution are satisfied. Citations. A motion under Section 144 grants to a litigant the power to request that a district court judge disqualify him or herself when that judge has demonstrated a personal bias or prejudice as against the subject litigant. Another citation. The statute sets forth a procedure for that inquiry to be determined as by the assignment of the proceeding to another sitting judge to A. Determine if the allegations in the submitted affidavit or declaration are truthful, B. Whether the allegations therein are legally sufficient, and C. Do they rise to the level of such demonstrated bias and prejudice to merit reassignment of the case to another sitting judge. Citation. The merits of any motion filed pursuant to Section 144 hinge upon the accompanying sworn statement of the movant as certified by his or her attorney. The sworn statement must show actual factual evidence that, according to the movant, demonstrates bias and prejudice that will infect the validity of the process. Citation. In order for the affidavit to be sufficient, it must contain something more than conclusions, something that Chile seems to do a lot of. Facts showing the existence of personal bias and prejudice on the part of the judge are essential. As this circuit has succinctly put it, affidavits of disqualification must allege personal rather than judicial bias. They must contain more than mere conclusions. They must show facts indicating the existence of a judge's personal bias and prejudice. Motions alleging bias and prejudice on the part of a judge, which establish simply that the affiant does not like a particular judge, are not adequate to require disqualifications. Hopefully my mic's still going. Here, Mr. Springer's declaration establishes that the appearance of the record and decisions of the court give the appearance that Judge Strickland either takes personal issue with the way that Mr. Springer lawfully conducted himself while exercising his fundamental liberties to speech, that is critical of his government, to petition for redress of grievances and of the press, or Judge Strickland has a bias towards the state judiciary supports that they enjoy a right to silence an individual who is not as polite or compliant as they want. We've got some ors and alls there. Mr. Springer's prior affidavit established that he was never unruly, though he disagreed with the court's rule about wearing a mask and exercised his right to speech on that public policy. He eventually left. He did, though he was unaware at the time, having recently come to New Mexico, take a video camera into the hearing room. The next time he tried to, by following the proper procedures for the press, he was denied entry by order of defendant Murdoch Poff. And he did, in a humorous fashion, engage in speech with the clerk to express his displeasure at the actions of his government to harass him as member of the press, requiring that he be escorted by law enforcement, though he had made no threats nor behaved in an unruly fashion. Was that a very long sentence? That goes from there, doesn't it? Hope you got that. The facts establish that at the time the court proceeded to grant an unrequested extension to the defaulting defendants, the only information provided to the court was what plaintiff provided, which are the videos that do not establish any legitimate or reasonable basis for denying him due process, for denying him his right to freely report on the court as an independent journalist, his right to engage in protected speech that is critical of his government, or to petition for redress of grievance. Yet Judge Strickland gave all benefit of the doubt to the judicial defendants, to the point of excusing them from showing cause, while they failed to follow Judge Riggs' order to comply with the rule of civil procedure to file a responsive pleading within 21 days of service of the complaint and summons. In accord, see citation, a judge should not recuse himself on unsupported, irrational, or highly tenuous speculation. And another citation. Similarly, allegations that are broad and conclusionary will not adequately support a motion filed under Section 144. Here as the declaration, I'm looking forward to the declaration, of Mr. Springer makes clear, rather than broad and conclusionary, the allegations of evidence of prejudice and bias are concrete and succinct, point to inexplicable deference towards the judicial defendants and against Mr. Springer to the detriment of the continued loss of his fundamental freedoms without any supported legitimate basis. It is a situation, as the Tenth Circuit has described it, of a personal nature, and must be such as would likely result in a decision on some basis other than what the judge learned from his participation in the case, i.e., a decision based upon deference towards a counterpart judiciary based in the judge's personal position as member of a judiciary. Citations. In accord, citations. The Code of Conduct for United States Judges, Canons 1 and 2A read, an independent and honourable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. The provisions of this code should be construed and applied to further that objective. A. Respect for law. A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. It's a shame auditors don't have codes of conduct, and maybe some for auditors' channels as well. Moreover, specifically in this case, the canons provide at 3C1A that a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances in which A. the judge has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceedings. And though plaintiff recognised that this court is not bound by the New Mexico rules of judicial conduct, defendants believe that the New Mexico rules shed light on what exactly would constitute a disqualifying condition. So hang on. So they're quoting rules of New Mexico conduct, judicial conduct, that the district court doesn't have to follow anyhow. A judge shall disqualify himself or herself in any proceedings in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of facts that are in dispute in the proceeding. Rule 21-211 N New Mexico RA. With all deference to this court, the impartiality of Judge Strickland can reasonably be called into question when she has on multiple instances expressed deference or bias for the state judiciary defendants, which is an understandably human response of sympathy towards individuals situated in similar circumstances, even though there is a distinct difference between the state and federal judiciary. Interestingly, you should recognise there's a difference there, but try and quote New Mexico rules for their own state judges as applying to federal district judges, who surely have their own rules. In fairness to Mr. Springer and the serious constitutional issues, he deserves to have a jurist that is free from any reasonable question of impartiality. So, he wants the judge recused. Next one. These are just the memos showing that stuff was sent in August. Nothing interesting in that exhibit. But this is the affidavit of James Springer. And I just want to go down the bottom. Yes, it is a new document. I didn't want to read an affidavit that I'd read before, but this one might be fun. I, James Springer, declare I have reviewed the filings of this case with my attorneys. I have never been obstructive, harassed, brackets, within any reasonable definition of that term, close brackets, or instructed any person to unlawfully interfere with the business of the 7th Judicial District Court. Yes, James, but have you inferred that they do that without directly asking them? I have neither instructed or used any language that would incite any other person to act unlawfully towards the 7th Judicial District or any employee thereof. I was unaware of the prohibition on members of the press recording in courtrooms or hearing rooms in New Mexico without first giving notice until after my encounter with Gordon Bennett, which occurred shortly after I moved to New Mexico. Ignorance of the law is no defence, I believe. After learning of the requirement, the next time I tried to attend a public hearing for the purpose of reporting, I gave proper notice of my intention to attend to record and report to Judge Shannon Murdoch-Poff. But after I gave notice, she issued an order barring me from attending a public proceeding. I was unaware of the mask mandate when I attended a public hearing in front of Gordon Bennett in early 2023. At that point, I was completely unaware of any other venue in the country that was requiring masking, as it had been admitted to be completely ineffective by the CDC. I believe that masking interferes with my right to engage in expressive speech by I believe that masking interferes with my right to engage in expressive speech by infringing upon my non-verbal communications expressed by my facial expressions. I did argue with Gordon Bennett about the policy, and when he expressed that I would comply with the rule on pain of contempt, I bridged my protest and reporting of the mask policy and left. My YouTube channel used for reporting on the affairs of government has over 440,000 subscribers, which is roughly the same number of subscribers as the 3 Albuquerque news TV stations combined on their YouTube channels. I don't know what percentage of his 440,000 watch him. It appears that despite filing and servicing my case in mid-June as a result of the threat of criminal prosecution by the defendants in this matter, because I could not comply with requirement to have a law enforcement escort whenever I entered a court facility, brackets, both the Torrance County Sheriff and the Moriarty Police refused to provide the same because they could not spare the resources for such an unnecessary action, close brackets, that the defendants have refused to comply with the requirements of the court's order and the rules of civil procedure, but rather than hold them to the same standard for those violations, that the court has instead allowed them extra months' worth of time, including extensions of time they did not request, and has not required them to explain why they are excused from following court orders or the rules. Instead, it is my understanding that court is requiring that I must show cause why my case should not be dismissed for lack of prosecution. In essence, there we have. This was in the other file, in the footnote there, before I continue that parent sentence, that apparently the criminal prosecution has been dropped. So where were we? Instead, it is my understanding that the court is requiring that I must show cause why my case should not be dismissed for lack of prosecution, in essence, explaining why I shouldn't suffer the loss of my constitutional freedoms because the defendants have failed to follow court order to provide an answer to my complaint as required by the rules, as my attorneys have explained them to me. I specifically request that this matter upon these facts be reviewed by a different judge to examine if it may be reasonably questioned that Judge Strickland has prejudice against me or a bias towards the defendants who are also judges or court personnel. I swear under penalty of perjury, etc., etc. Did he actually... I haven't seen really in his affidavit any reasoning as may be required. I don't know. I would have thought he'd need more. Hey-ho, we'll wait and see if the judge recuses herself. She may well do so just to get him off her hands, but who knows? All right, do we go on to the next one? Let me just peep as to how many people. 78 of you. I will continue. I will continue. I know this is dry. Right, the next one is the defendant's motion to set aside entry of default. Hang on. So he motioned for default. He's now motioning to set aside the entry of the default. Interesting. Comes now defendant's 7th Judicial District. Oh, hang on. Sorry. Beg my pardon. You know it's late. This isn't a Springer motion. This is the defendant's motion. I just caught on. It's just gone 1 a.m. I've obviously done 2 Springer motions, so I was confused. This is the defendant's motion. So the defendants are trying to set aside the default and ignore everything I said in the last 2 minutes. Comes now defendants, 7th Judicial District Court, Mercedes Murphy, Shannon Murdoch-Poff, Jason Jones and Susan. I think it should be Susan, but it's the defendants. They probably made the typo. Resignal. By and through their Council of Record, Garcia Law Group, and respectfully request this court set aside the clerk's entries of default filed on August 8, 2023 in this matter. I thought it was going to be dry. I know, Paul. Yeah, I did get there eventually. I got there eventually. Yeah, okay, I'll accept it. But it is 1 a.m. Come on. Do we need the background? I'm not sure we need to read the background on this one. I don't. I think the background. I'm not going to read the background. Because that's just going through the docket, really. Right, let's start here. So I'm starting. Defendants have retained counsel to defend them in matter, and as evidenced by the response to plaintiff's application for temporary restraining order filed herein, have manifested as intent to defend themselves. Further, defendants assert that they have meritorious defences to this plaintiff's claims and intend to move for dismissal of plaintiff's complaint. Accordingly, the clerk's entries of default should be set aside and the parties permitted to proceed with litigation. Legal standard. Rule 55 of the Federal Rules of Civil Procedure sets out a 2-step process for a default judgment. First, a party must obtain a clerk's entry of default. See Federal Rule of Civil Procedure 55 brackets A. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. Citation. Entry of default by the clerk is a necessary prerequisite that must be performed before a district court is permitted to issue a default judgment. Second, the party must either request the clerk to enter default judgment when the claim is for a sum certain or a sum that can be made certain by computation, or, in all other cases, the party must apply to the court for a default judgment. Pursuant to Rule 55, a party may apply to the court for a default judgment after a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend against the action. A court may conduct hearings to conduct an accounting, determine the amount of damages, establish the truth of any allegation by evidence, or investigate any other matter. Even still, there is no right to a default judgment, and the entry of a default judgment is committed to the sound discretion of the district court. Citation. If a party in default acts before entry of judgment, Federal Rule of Civil Procedure 55C provides that the court may set aside an entry of default for good cause. And the citation is, default judgments are a harsh sanction. And it's a 10th Circuit 1991 citation. As such, default judgments are not favoured by courts. Another citation. Further, courts do not favour such a sanction purely as a penalty for delays in filing or other procedural error. Another citation. Because of a default judgment's disfavoured status, the good cause required by Rule 55C for setting aside entry of default poses a lesser standard for the defaulting party than the excusable neglect which must be shown for relief from judgment under Rule 60B. Citations. And that's stating that the good cause standard is fairly liberal because the preferred disposition of any case is upon its merits and not by default judgment. Sand. Legal argument. The distinction between an entry of default and a default judgment. The distinction between setting aside an entry of default and setting aside a default judgment reflects the different consequences of the two events and the different procedures that bring them about. For an entry of default, the clerk may enter a default upon the application of the non-defaulting party. This entry is merely an official recognition of the fact that one party is in default and is an interlocutory step that is taken under Rule 55A in anticipation of a final judgment by default under Rule 55B. Citation. In sharp contrast, a final default judgment is not possible against a party in default until the measure of recovery has been ascertained, which typically requires a hearing in which the defaulting party may participate. Now, I'm old, and I remember when we used to have, I worked where stuff needed to be correct and proofread against a draft, etc. And fairly junior people would do this proofreading. But it does seem that in the days of when people type their own stuff, that proofreading has gone out the window. Because if stuff was proofread, they would pick up things like that. Sorry. In which the defaulting party may participate. In some situations, a jury trial may be made available to determine an issue of damages. Moreover, the entry of a default judgment is a final disposition of the case and an appealable order. Yes, back in the day, we used to have secretaries who typed. However, a defaulting party is not entitled to relief from a judgment as a matter of right under Rule 60B. The movement must present a justification supporting the motion and must establish its contentions if challenged. Further, a motion to set aside default judgment is subject to the explicit provisions of Rule 60B, which places additional restraints upon the court's discretion. Conversely, a motion to set aside a default entry may be granted for good cause shown. This lower standard gives the court greater freedom in granting relief than is available in the case of default judgments. While there are some differences between setting aside the entry of default and setting aside a default judgment, there are some important similarities, including that courts may consider the same factors: whether the party willfully defaulted, whether setting aside the entry of default or default judgment would prejudice the non-movement, and whether the movement has presented a meritorious defence. Citation. And that citation is: in deciding whether to set aside an entry of default, courts may consider, among other things, whether the default was willful, whether setting it aside would prejudice the adversary, and whether a meritorious defence is presented. Another citation. 3 requirements must be met when setting aside a default judgment under Rule 60B. 1. The moving party's culpable conduct did not cause the default. 2. The moving party has a meritorious defence. And 3. The non-moving party will not be prejudiced by setting aside the judgment. 2. Default is improper given that defendants have manifested an intent to defend themselves. Strong policies favour resolution of disputes on their merits. The preferred disposition of any case is upon its merits and not by default judgment. Unless, I was just checking that my mic was going, sorry. Unless the preference is counterbalanced by considerations of social goals, justice and expediency. Citation. The default judgment must normally be viewed as available only when the adversary process has been halted because of an essentially unresponsive party. In that instance, the diligent party must be protected lest he be faced with interminable delay and continued uncertainty as to his rights. The default judgment remedy serves as such a protection. Citation. Counsel for defendants entered an appearance 7 days after plaintiff's... Sorry, I've got to make it make sense. Counsel for defendants entered an appearance 7 days after plaintiff filed an application for entry of default. There's a missing word there. Defendants subsequently filed their response to plaintiff's application for temporary restraining order. In filing their response, defendants have expressly manifested an intent to defend themselves. Plaintiff, therefore, cannot reasonably assert that defendants is an essentially unresponsive party. Neither can plaintiff argue that the adversary process has been halted or that he faces interminable delay because of defendant's actions. As of the filing of this motion, plaintiff has not moved for default judgment, and defendant's motion to dismiss is forthcoming. Because defendants are defending themselves and because courts have a strong preference to resolve cases on their merits rather than by procedural default, the clerk's entry of default as to Chief Judge Murphy, Judge Murdoch-Poff, Mr. Jones and Ms. Rosignol, and the clerk's entry of default as to the 7th Judicial District Court should be set aside. 3. Good cause exists to set aside default, the entries of default. Does that make sense? Good cause exists to set aside default, the entries of default. I think there's a title there that doesn't make sense. If you disagree with me, put so in chat. To determine if the moving party has proven good cause, the district court should consider the following 3 factors. 1. Whether the default was willful. 2. Whether setting default aside without prejudice. 2. Whether setting default aside would prejudice the adversary. And 3. Whether a meritorious defence is presented, and their citation. These factors are not talismanic. Citation. The district court need not consider each factor and may also consider other factors. Finally, the defaulting party has the burden of proving that the default and default judgment should be set aside. Citation. Here the good cause factors weigh in favour of setting aside the entry of default against defendants under Federal Rule of Civil Procedure 55C. A. The entry of default should be set aside because defendants did not default willfully. Concerning the first factor, willfulness, also referred as culpability. Generally, a party's conduct will be considered culpable only if the party defaulted willfully or had no excuse for the default. Citation. Defendant's failure to answer was not a willful disregard for the court. On the contrary, defendants filed their response to plaintiff's application for temporary restraining order, preliminary injunction, and intended for the filing to function as an answer to the complaint as well, given the affirmative defences raised. This confusion was a result of the complaint being combined with the application for restraining temporary order, preliminary injunction. Defendants are ready, willing, and able to defend themselves and will be filing a motion to dismiss plaintiff's complaint. Further courts disfavour default judgment purely as a penalty for delays in filing or other procedural error. Citation. Therefore, defendant's failure to timely answer is insufficient by itself to obtain default judgment under the plaintiff's allegations in his complaint. In addition, defendant sought to retain legal counsel for this matter. Defence counsel needed time to complete the firm's conflicts checks due to defendant's positions in the judiciary and entered the appearance promptly after the conflicts checks were clear. This due diligence does not rise to the level of culpable conduct under Rule 55(c), and therefore the first factor weighs in defendant's favour. B. The entry of default should be set aside because there is no prejudice to plaintiff. As to the second factor, there is no prejudice that would result to the plaintiff if the entry of default is set aside. The 10th Circuit has explained that the default judgment must normally be viewed as available only when the adversary process has been halted because of an essentially unresponsive party. Citation. That is not the case here. As of the filing of this motion, this case was relatively new. Plaintiff filed his complaint on June 9, 2023 and obtained clerk's entries of default on August 8, 2023. Plaintiff's application for restraining order preliminary injunction was denied September 21, 2023, and this court gave plaintiff a deadline of October 5, 2023 to move for default judgment. Defenders promptly move herein to set aside the clerk's entries of default. Citations. And this says, courts have consistently held that an unintentionally or good faith mistake does not rise to the level of culpable conduct under Rule 55C, particularly where a party takes prompt action to remedy its error. Accordingly, the second Rule 55(c) factor weighs in defendant's favour. C. The entry of default should be set aside because defendants have meritorious defences. The third factor examines whether defendants have asserted a meritorious defence. For this factor, defendants are not required to persuade the court that they is likely. For this factor, defendants are not required to persuade the court that they are likely to prevail on their defences. Citation. A movement is not required to demonstrate a likelihood of success on the merits. Rather, the court examines the allegations contained in the moving papers to determine whether the movement's version of the factual circumstances surrounding the dispute, if true, would constitute a defence to the action. Citation. Whether or not those allegations are true is not determined by the court upon the motion to set aside the default, but would be the subject of later litigation. Citations. Defendants will explain in a separate motion to dismiss how their version of the facts, if proven at trial, would constitute a legally cognizable defence to the action of plaintiff's allegations. Citation, and that's stating that a meritorious defence must be legally cognizable. This motion to dismiss will demonstrate how the meritorious defence prong weighs in defendant's favour. 4. The entries of default should be set aside because plaintiff has not properly served defendants. The Federal Rules of Civil Procedures establish service of process for individuals and governmental defendants. E. Serving an individual within a judicial district of the United States. Unless federal law provides otherwise, an individual other than a minor, an incompetent person, or a person whose waiver has been filed may be served in a judicial district of the United States by 1. Following state law for serving a summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is made, or 2. Doing any of the following. A. Delivering a copy of the summons and of the complaint to the individual personally. B. Leaving a copy of each at the individual's dwelling or usual place of abode, which someone of suitable age and discretion who resides there. Or C. Delivering a copy to each to an agent authorised by appointment or by law to receive service of process. J. Serving a foreign state or local government. 2. State or local government, a state, a municipal corporation, or any other state-created governmental organisation that is subject to suit must be served by A. Delivering a copy of the summons of the complaint to its chief executive officer, or B. Serving a copy of each in the manner prescribed by that state's law for serving a summons or like process on such a defendant. Plaintiff's first option under Rule 4J is to deliver a copy of the summons and complaint to defendant's chief executive officers. Here plaintiff served Ms. Rosignol personally and attempted to serve the 7th Judicial District Court, Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones through Ms. Rosignol. Defendant acknowledges that Ms. Rosignol was served personally, but argues that service on the remaining defendants was insufficient. Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones were not served personally, nor at their dwelling or usual place of abode. Neither is Ms. Rosignol an agent authorised by appointment or law to accept the service on their behalf. The 7th Judicial District Court was not served delivering a copy of the summons and of the complaint to its chief executive officer, nor as prescribed by the state of New Mexico laws for serving a summons or like process on other state-created governmental organisation. Plaintiffs subsequently filed a certificate of service on July 19, 2023, stating that the summons and complaint were served through Judge Murphy's proposed text email on June 21, 2023, and on the court clerk for the 7th Judicial District at their address on July 13, 2023, by a process server. However, the affidavit of service provides no information as to the identity of the clerk the process server served. Further, the same deficiencies of service above remain. The New Mexico Rules of Civil Procedure do not authorize the court clerk to accept service for the court or court officer, official, or employee. By contrast, those same rules authorize a county clerk to be served for a county and for a city clerk to be served for a municipal corporation. Because plaintiffs served the summons and complaint to an individual not authorized to accept service on defendant's behalf, plaintiff has failed to satisfy the rules of civil procedure. Accordingly, plaintiff has not shown effective service on the 7th Judicial Circuit Court, Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones under Rule 4E, nor under Rule 4J. The second option for service under Rule 4J2 is to serve a copy of the summons and complaint in the manner prescribed by the law of the state of New Mexico. The New Mexico Rules of Civil Procedure establishes service of process for governmental defendants. H. I don't know if I can be bothered reading another set of rules. I'm going to just scroll through there. And we'll see how they say they didn't comply. As described above, plaintiff attempted to effect service on the 7th Judicial District Court Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones through Ms. Rosignol, emailing a copy of the complaint and summonses to Judge Murphy's proposed text email and serving a court clerk via process server. Defendants reassert their above argument that service is not proper because plaintiffs served the summons and complaint to an individual not authorized to accept service on defendant's behalf. Under New Mexico's service rules, the 7th Judicial Court must be served by delivering a copy of the process to the head of the 7th Judicial District Court, which is the Chief Judge. With respect to Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones, they must be served by delivering a copy of the process by delivering a copy of the process to the officer, official or employee. I think there's two entries of that there. Delivery under Rule 4J2 requires use of process server. Other jurisdictions have rejected mailing to be delivery. Citation. Holding service by mail on the governor was deficient under Rule 4J2 (A) because mailing is not delivering under Rule 4. If mail is insufficient for service for Federal Rule 4J, so too would email be insufficient under State Rule 1-004 (H). Accordingly, plaintiff has not shown effective service on 7th Judicial District Court Chief Judge Murphy, Judge Murdoch-Poff and Mr. Jones. Plaintiff's attempt to effect service upon all defendants is also insufficient because he has not demonstrated service on the New Mexico Attorney General as required by Rule 1004 (H) and the other rule. For a state governmental entity and an officer, official, or employee thereof, both the named defendant and the New Mexico Attorney General must be served. Musted be served. Mustard? Mustard. Notably, there is not a single summons return for the Attorney General on any defendant named herein, nor were any summons even issued for the Attorney General on said defendants. Therefore, plaintiff has not met his burden to show service on a designated registered agent, the Chief Executive Officer, and or any other person authorized by law to accept service of process, nor on the New Mexico Attorney General. Now, I know when the default was entered, Merv said something about he didn't know what the defendants were doing. Well, this might explain it. If service was never actually affected, apart from on one individual. For these reasons, plaintiff has failed to show effective service under Federal Rule of Civil Procedure P4J and Rule 1004 (8) New Mexico rules, Absent proof of proper service, plaintiff is not entitled to default judgment against defendants, and entries of default should be set aside. Conclusion. Good cause exists to set aside the clerk's entries of default against defendants. First, the factors for setting aside the entry of default under Federal Rule of Civil Procedure 55C shows that all three factors favour the defendants because defendants' conduct leading to the default was not culpable. Setting aside the default would not prejudice the plaintiff, and defendants have meritorious defences for Rule 55(c) purposes. Second, defendants have expressly manifested their intent to defend against this lawsuit. Third, plaintiff has not properly served defendants. For these reasons, the clerk's entries of default should be set aside and the parties should proceed with litigation. Wherefore, defendants request that this court 1. Grant their motion to set aside entries of default, 2. Enter an order setting aside a clerk's entry of default as to Chief Judge Murphy, Judge Murdoch-Poff, Mr. Jones and Ms. Rosignol, 3. Enter an order setting aside clerk's entry of default as to the 7th Judicial District Court, and 4. Grant all other relief as this court deems just and proper. Jeez. Right. So that's... We got one more. How many pages? It's only 3 pages. It's only 3 pages. Right. So this is opposed motion for stay and injunction pending appeal. So this is a Springer motion. Back to a Springer motion. But this was docket entry number 42, I believe, today. So it's fun. We've had 3 Springer motions today and 1 defendant's motion. So this is opposed motion for stay and injunction pending appeal. Comes now plaintiff through undersigned counsel with his request for this court to issue a stay of the proceedings before the court, an injunction barring that the defendants may take no action to prevent plaintiff's free exercise of his rights to speech, press, and to petition his government for redress during the pendency of the appeal. 1. Out of an abundance of caution pursuant to Rule 8, Federal Rule of Procedure. Out of abundance of caution pursuant to Rule 8, Federal Rule of Appellant Procedure, plaintiff respectfully requests that this court issue an injunction pending an appeal of this court's order denying the request for a preliminary injunction requested the same relief. 2. Plaintiff respectfully offers that this case plainly satisfies Rule 8A's impracticable exception, as it will likely be futile to ask this court for the same relief the court has just denied to them in rejecting their injunction motion. And their citations. 3. For further explanation in support of the instant motion, plaintiff offers that court did not find that no equitable... Plaintiff offers that court made... Sorry, when it doesn't make sense and it's this late. For further explanation in support of the instant motion, plaintiff offers that court did not find that no irreparable harm was impacting plaintiff, only that plaintiff had insufficiently pleaded or briefed his likelihood of success on the merits despite no evidence being produced by defendants to support their allegations. 4. The district court rendered its decision without oral argument and without an evidentiary hearing. 5. The plaintiff further requests this honourable court stay its proceeding during the pendency of the interlocutory appeal or any applications for injunctive relief to the Supreme Court of the United States. Wherefore, plaintiffs respectfully request this court issue an injunction pending appeal that bars the defendants from enforcing any order or taking any action which infringes upon plaintiff's free exercise of rights protected by the First Amendment in the 7th Judicial District Court's facilities, as long as he complies with all applicable rules. And that's submitted again by Springer's attorneys. And as I said, that was document 42. If you stayed with me, just how many have stayed with me? Well, we're still at 61. Or 65, I think. I don't know. 61, 65. A lot of people still consider him What's Tay's auditor says? Good positive. If English isn't my first language, come on, come on, come on. It's late. It's late, and God, there was a bloody lot there. Oh, that isn't Alex trying to talk to me, is it? I tried Clark. Oh, you're. Am I saying Clark wrong? But if he applies to the rules, he will be submitting to lose his First Amendment right. I think that's fairly interesting. No doubt one or two lawyers will weigh in on the merits of these motions. I think the fact that they're raising that they weren't served correctly is very interesting, considering that, you know, there's Springer has lawyers attorneys acting for him on this who should know what they're doing. Then again, they appear to almost be wanting what Springer wants, so they're almost like he's their body for them to get what they want, i.e. Springer is doing what they want him to do. Yeah, I've just had a message that it may be time to end my video, and yeah, you're entirely correct. I was going to end anyway, because I am fatigued. I don't know how long it's been, and I read them through for the first time. Lieutenant, not lieutenant. Thanks for joining me. For those that stay from start to finish, you deserve an award. I don't know if you noticed, I think in the description there's a link to a form where you can join my membership, which is totally free, and you can choose whether you want to become a tadpole or a frog leg. And of course, and you can also choose what number of tadpole or frog leg you want to be. So please do fill that in, and then when your name comes up, I may try and say, well, it's tadpole number 3 or frog leg number 53 speaking.